Well, my friends, every day that goes by, we learn something new. This was sent to me by a subscriber in a comment section in a link that I decided to follow because it looked very interesting. This is an article by Jean-Michel Lettner, and it was written September 7th, 2016. I mean, are they trying to suppress this? 58 likes and 42 comments. Missing 13th Amendment found. No lawyers in public office. I've been saying this for years. Lawyers should stick to their scams and schemes and not leave it in government. Anyway, here's the article. The 13th Amendment to the Constitution of the United States has been altered from its original in order to fool the American public into accepting a government that is mostly illegally in office. The information contained in the article below contains stunning revelations that the entire U.S. Congress should be deemed illegitimate after evidence that a clandestine plot to alter the U.S. Constitution has now emerged. The Millennium Report reports. In the winter of 1983, archival research expert David Dodge and former Baltimore police investigator Tom Dunn were searching for evidence of government corruption in public records stored in the Belfast Library on the coast of Maine. By chance, they discovered the library's oldest authentic copy of the Constitution of the United States, printed in 1825. Both men were stunned to see this document included a 13th Amendment that no longer appears on current copies of the Constitution. Moreover, after studying the amendment's language and historical context, they realized the principal intent of this missing 13th Amendment was to prohibit lawyers from serving in government. So began a 7-year nationwide search for the truth surrounding the most bizarre constitutional puzzle in American history: the unlawful removal of a ratified amendment from the Constitution of the United States. What have I been saying, ladies and gentlemen? Didn't I say that this corruption goes back more than 100 years? I've been saying this for years. Since 1983, Dodge and Dunn have uncovered additional copies of the Constitution with the missing 13th Amendment printed in at least 18 separate publications by 10 different states and territories over 4 decades from 1822 to 1860. In June of this year, 1991, Dodge uncovered the evidence that this missing 13th Amendment had indeed been lawfully ratified by the state of Virginia and was therefore an authentic amendment to the American Constitution. If the evidence is correct and no logical errors have been made, a 13th Amendment restricting lawyers from serving in government was ratified in 1819 and removed from the U.S. Constitution during the tumult of the Civil War. Since the amendment was never lawfully repealed, it is still the law today. The implications are enormous. The story of this missing amendment is complex and at times confusing because the political issues and vocabulary of the American Revolution were different from our own. However, there are essentially 2 issues. What does the amendment mean, and was the amendment ratified? Before we consider the issue of ratification, we should first understand the amendment's meaning and consequent current relevance. Meaning of the 13th Amendment. The missing 13th Amendment to the Constitution of the United States reads as follows. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind or whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. At the first reading, the meaning of this 13th Amendment, also called the Title of Nobility Amendment, seems obscure, unimportant. The references to nobility, honor, emperor, king, and prince lead us to dismiss this amendment as a petty post-revolution act of spite directed against the British monarchy. The U.S. modern world of Lady Di and Prince Charles make anti-royalist sentiments seem so archaic and quaint that the amendment can be ignored. Not so. Consider some evidence of its historical significance. First, titles of nobility were prohibited in both Article 4 of the Articles of Confederation in 1777 and in Article 1, Sections 9 and 10 of the Constitution of the United States in 1787. Second, although already prohibited by the Constitution, an additional Title of Nobility Amendment was proposed in 1789, again in 1810, and according to Dodge, finally ratified in 1819. Clearly, the Founding Fathers saw such a serious threat in titles of nobilities and honors that anyone receiving them would forfeit their citizenship. Since the government prohibited titles of nobility several times over 4 decades and went through the amending process even though titles of nobility were already prohibited by the Constitution, it is obvious that the amendment carried much more significance for our Founding Fathers than is readily apparent today. Historical context. To understand the meaning of this missing 13th Amendment, we must understand its historical context, the era surrounding the American Revolution. We tend to regard the notion of democracy as benign, harmless, and politically unremarkable. But at the time of the American Revolution, King George III and other monarchies of Europe saw democracy as an unnatural, ungodly, ideological threat, every bit as dangerously radical as communism was once regarded by modern Western nations. Just as the 1917 Communist Revolution in Russia spawned other revolutions around the world, the American Revolution provided an example and incentive for people all over the world to overthrow their European monarchies. Even though the Treaty of Paris ended the Revolutionary War in 1783, the simple fact of our existence threatened the monarchies. The United States stood as a heroic role model for other nations that inspired them to also struggle against oppressive monarchies. The French Revolution, 1789 to 1799, and the Polish National Uprising in 1794 were in part encouraged by the American Revolution. Though we stood like a beacon of hope for most of the world, the monarchies regarded the United States as a political typhoid Mary, the principal source of radical democracy that was destroying monarchies around the world. The monarchies must have realized that if the principal source of that infection could be destroyed, the rest of the world might avoid the contagion and the monarchies would be saved. Their survival at stake, the monarchies sought to destroy or subvert the American system of government. Knowing they couldn't destroy us militarily, they resorted to more covert methods of political subversion, employing spies and secret agents skilled in bribery and legal deception. It was perhaps the first Cold War. Since governments run on money, politicians run for money, and money is the usual enticement to commit treason. Much of the monarchy's counter-revolutionary efforts emanated from English banks. Don't bank on it. Modern banking system. The essence of banking was once explained by Sir Josiah Stamp, a former president of the Bank of England. The modern banking system manufactures money out of nothing. The process is perhaps the most astounding piece of sleight of hand that was ever invented. Banking was conceived in inequity and born in sin. Bankers own the earth. Take it away from them, but leave them the power to create money, and with a flick of a pen, they will create enough money to buy it back again. Take this great power away from them, or if you want to continue to be the slaves of bankers and pay the cost of your own slavery, then let bankers continue to create money and control credit. The last great abuse of the U.S. banking system caused the Depression of the 1930s. Today's abuses may cause another. Current S&L and bank scandals illustrate the ongoing relationship between banks, lawyers, politicians, and government agencies. Look at the current BCCI bank scandal involving lawyer Clark Clifford, politician Jimmy Carter, and the Federal Reserve, the FDIC, and even the CIA. These scandals are the direct result of years of law-breaking by an alliance of bankers and lawyers using their influence and money to corrupt the political process and rob the public. Think you're not being robbed? Guess who's going to pay the bill for the excesses of the S&Ls? The U.S. taxpayer. You are. The systematic robbery of productive individuals by parasitic bankers and lawyers is not a recent phenomenon. This abuse is a human tradition that predates the Bible and spread from Europe to America despite early colonial prohibitions. When the first United States Bank was chartered by Congress in 1790, there were only 3 state banks in existence. At one time, banks were prohibited by law in most states because many of the early settlers were all too familiar with the practices of the European goldsmith banks. Goldsmith banks were safe houses used to store clients' gold. In exchange for the deposited gold, customers were issued notes, or paper money, which were redeemable in gold. The goldsmith bankers quickly succumbed to the temptation to issue extra notes, unbacked by gold. Why? Because the extra notes enriched the bankers by allowing them to buy property with notes for gold that they did not own. Gold that did not even exist. Colonists knew that bankers occasionally printed too much paper money, found themselves over-leveraged, and caused a run on the bank. If the bankers lacked sufficient gold to meet the demand, the paper money became worthless, and common citizens left holding the paper were ruined. Although over-leveraged bankers were sometimes hung, the bankers continued printing extra money to increase their fortunes at the expense of the productive members of society. The practice continues to this day and offers sweetheart loans to bank insiders and even provides the foundation for deficit spending and the U.S. federal government's unbridled growth. Paper money. If the colonists forgot the lessons of goldsmith bankers, the American Revolution refreshed their memories. To finance the war, Congress authorized the printing of continental bills of credit in an amount not to exceed $200 million. The state issued another $200 million in paper notes. Ultimately, the value of the paper money fell so low that they were soon traded on speculation from 5,000 to 1,000 paper bills for one coin. It is often suggested that the U.S. Constitution's prohibition against a paper economy, no state shall make anything but gold and silver coin a tender in payment of debts, was a tool of the wealthy to be worked to the disadvantage of all others. But only in paper economy can money reproduce itself and increase the claims of the wealthy at the expense of the productive. Paper money, said Petaliah Webster, polluted the equity of our laws, turned them into engines of oppression, corrupted the justice of our public administration, destroyed the fortunes of thousands who have confidence in it, enervated the trade, husbandry, and manufactures of U.S. country, and went far to destroy the morality of the U.S. people. Conspiracies. A few examples of the attempts by the monarchies and banks that almost succeeded in destroying the United States. According to the Tennessee Laws, 1715 to 1820, Volume 2, page 774, in the 1794 Jay Treaty, the United States agreed to pay 600,000 pounds sterling to King George III as reparations for the American Revolution. The Senate ratified the treaty in secret session and ordered that it not be published. When Benjamin Franklin's grandson published it anyway, the exposure and resulting public uproar so angered Congress that it passed the Alien and Sedition Acts, 1798, so federal judges could not prosecute editors and publishers for reporting the truth about the government. Since we had won the Revolutionary War, why would U.S. senators agree to pay reparations to the loser? And why would they agree to pay £600,000 sterling 11 years after the war ended? It doesn't make sense, especially in light of Senate secrecy and later fury over being exposed, unless we assume U.S. senators had been bribed to serve the British monarchy and betray the American people. That's subversion. The United States Bank had been opposed by the Jeffersonians from the beginning, but the Federalists, the pro-monarchy party, won out in its establishment. The initial capitalization was $10 million, 80% of which would be owned by foreign bankers. Since the bank was authorized to lend up to $20 million, double its paid-in capital, it was a profitable deal for both the government and the bankers, since they could lend and collect interest on $10 million that didn't exist. However, the European bankers outfoxed the government, and by 1796, the government owned the bank, $6,200,000, and was forced to sell its shares. By 1802, the U.S. government owned no stock in the United States Bank. The sheer power of the banks and their ability to influence representative government by economic manipulation and outright bribery was exposed in 1811, when the people discovered that European banking interests owned 80% of the bank. Congress therefore refused to renew the bank's charter. This led to the withdrawal of $7 million in specie by European investors, which in turn precipitated an economic recession and the War of 1812. That's destruction. There are undoubtedly other examples of the monarchy's efforts to subvert or destroy the United States. Some are common knowledge, others remain to be disclosed to the public. For example, David Dodge discovered a book called 2VA Law in the Library of Congress Law Library. According to Dodge, this is an uncatalogued book in the rare book section that reveals a plan to overthrow the constitutional government by secret agreements engineered by the lawyers. That is one of the reasons why this amendment was ratified by Virginia and the notification was lost in the mail. There is no public record that this book exists. That may sound surprising, but according to the Gazette 51091, the Library of Congress has 349,402 uncatalogued rare books and 13.9 million uncatalogued rare manuscripts. There may be secrets buried in that mass of documents even more astonishing than a missing constitutional amendment. Titles of nobility. In seeking to rule the world and destroy the United States, bankers committed many crimes. Foremost among these crimes were fraud, conversion, and plain old theft. To escape prosecution for their crimes, the bankers did the same thing any career criminal does. They hired and formed alliances with the best lawyers and judges money could buy. These alliances, originally forged in Europe, particularly in Great Britain, spread to the colonies and later into the newly formed United States of America. And just a note here, ladies and gentlemen, I've been saying for a long time that I doubt very seriously that we won the Revolutionary War. I've been saying, I know it sounds crazy, but I think it's going to come out that some form of tomfoolery between the banks and England and the United States is the greatest mindfuck in human history. Continuing with the article, despite their criminal foundation, these alliances generated wealth and ultimately respectability. Like any modern member of organized crime, English bankers and lawyers wanted to be admired as legitimate businessmen. As their criminal fortunes grew, so did their usefulness, so the British monarchy legitimized these thieves by granting them titles of nobility. Historically, the British peerage system referred to knights as squires and those who bore the knight's shields as esquires. As lances, shields, and physical violence gave way to more civilized means of theft, the pen grew mightier and more profitable than the sword, and the clever wielders of those pens, bankers and lawyers, came to hold titles of nobility. The most common was esquire, used even today by some lawyers. International Bar Association. In colonial America, attorneys trained attorneys, but most held no title of nobility or honor. There was no requirement that one be a lawyer to hold the position of district attorney, attorney general, or judge. A citizen's counsel of choice was not restricted to a lawyer. There were no state or national bar associations. The only organization that certified lawyers was the International Bar Association, chartered by the King of England, headquartered in London, and closely associated with the international banking system. Lawyers admitted to the IBA received the rank Esquire, a title of nobility. Esquire was the principal title of nobility which the 13th Amendment sought to prohibit from the United States. Why? Because the loyalty of esquire lawyers was suspect. Bankers and lawyers with an esquire behind their names were agents of the monarchy, members of an organization whose principal purposes were political, not economic, and regarded with the same wariness as some people today reserve for members of the KGB or the CIA. Article 1, Section 9 of the Constitution sought to prohibit the International Bar Association or any other agency that granted titles of nobility from operating in America, but the Constitution neglected to specify a penalty, so the prohibition was ignored, and agents of the monarchy continued to infiltrate and influence the government, as in the Jay Treaty and the U.S. Bank Charter incidents. Therefore, a title of nobility amendment that specified a penalty, loss of citizenship, was proposed in 1789 and again in 1810. The meaning of the amendment is seen in its intent to prohibit persons having titles of nobility and loyalties to a foreign government and bankers from voting, holding public office, or using their skills to subvert the government. Honor. The missing amendment is referred to as the Title of Nobility Amendment, but the second prohibition against honor may be more significant. According to David Dodge, Tom Dunn, and Webster's Dictionary, the archaic definition of honor, as used when the 13th Amendment was ratified, meant anyone obtaining or having an advantage or privilege over another. A contemporary example of an honor granted only to a few Americans is the privilege of being a judge. Lawyers can be judges and exercise the attendant privileges and powers non-lawyers cannot. By prohibiting honors, the missing amendment prohibits any advantage or privilege that would grant some citizens an unequal opportunity to achieve or exercise political power. Therefore, the second meaning or intent of the 13th Amendment was to ensure political equality among all American citizens by prohibiting anyone, even government officials, from claiming or exercising a special privilege or power and honor over other citizens. If this interpretation is correct, honor would be the key concept in the 13th Amendment. Why? Because while titles of nobility may no longer apply in today's political system, the concept of honor remains relevant. For example, anyone who has specific immunity from lawsuits which are not afforded to all citizens would be enjoying a special privilege and honor, and would therefore forfeit his right to vote or hold public office. Think of the immunities from lawsuits that U.S. judges, lawyers, politicians, and bureaucrats currently enjoy. As another example, think of all the special interest legislation the U.S. government passes. Special interests are simply euphemisms for special privileges or honors. What if? Implications if restored. If the missing 13th Amendment were restored, special interests and immunities might be rendered unconstitutional. This is what I've been saying for years and years on my website. That I'll leave a link in the description section for an article I wrote titled "Above the Law." Some of these people are above the law, and it shouldn't be. And I've been saying this for years. The prohibition against honors or privileges would compel the entire government to operate under the same laws as the citizens of this nation. Without their current personal immunities or honors, U.S. judges and IRS agents would be unable to abuse common citizens without fear of legal liability. If this 13th Amendment were restored, the entire U.S. government would have to conduct itself according to the same standards of decency, respect, law, and liability as the rest of the nation. If this amendment and the term honor were applied today, U.S. government's ability to systematically coerce and abuse the public would all be eliminated. Imagine a government without the special privileges or immunities. How could we describe it? It would be almost like a government of the people, by the people, and for the people. Imagine a government whose members were truly accountable to the public, a government that could not systematically exploit its own people. It's unheard of. It's never been done before, not ever in the entire history of the world. Bear in mind that Senator George Mitchell of Maine and the U.S. National Archives concede this 13th Amendment was proposed by Congress in 1810. However, they explained that there were 17 states when Congress proposed the title of Nobility Amendment that ratification required that 13 states, but since only 12 states supported the amendment, it was not ratified. The government printing office agrees. It currently prints copies of the Constitution of the United States, which include the title of Nobility Amendment as proposed but unratified. Even if this 13th Amendment were never ratified, even if Dodge and Dunn's research or reasoning is flawed or incomplete, it would still be an extraordinary story. Can you imagine? Can you understand how close the U.S. came to having a political paradise right here on Earth? Do you realize what an extraordinary gift our forebears tried to bequeath to us, and how close we came? One vote, one state's vote. The federal government concedes that 12 states voted to ratify this amendment between 1810 and 1812, but they argued that ratification required 13 states, so the amendment lays stillborn in history, unratified for lack of just one more state's support. One vote. David Dodge, however, says one more state did ratify, and he claims he has the evidence to prove it. Paradise lost, ratification found. In 1789, the House of Representatives compiled a list of possible constitutional amendments, some of which would ultimately become our Bill of Rights. The House proposed 17. The Senate reduced the list to 12. During this process, that Senator Tristan Dalton of Massachusetts proposed an amendment seeking to prohibit and provide a penalty for any American accepting a title of nobility, RG 46 Records of the United States Senate. Although it wasn't passed, this was the first time a title of nobility amendment was proposed. 20 years later, in January 1810, Senator Reed proposed another title of nobility amendment, History of Congress Proceedings of the Senate, page 529 to 530. On April 27, 1810, the Senate voted to pass this 13th Amendment by a vote of 26 to 1. The House resolved in the affirmative 87 to 3, and the following resolve was sent to the states for ratification. Quote, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. End quote. The Constitution requires 3/4 of the states to ratify a proposed amendment before it may be added to the Constitution. When Congress proposed the title of nobility amendment in 1810, There were states, 13 of which would have to ratify for the amendment to be adopted. According to the National Archives, the following is a list of the 12 states that ratified and their dates of ratification. Maryland, December 25th, 1810. Kentucky, January 31st, 1811. Ohio, January 31st, 1811. Delaware, February 2nd, 1811. Pennsylvania, February 6th, 1811. New Jersey, February 13th, 1811. Vermont, October 24th, 1811. Tennessee, November 21st, 1811. Georgia, December 13th, 1811. North Carolina, December 23rd, 1811. Massachusetts, February 27th, 1812. New Hampshire, December 10th, 1812. Before the 13th state could ratify, the War of 1812 broke out with England. By the time the war ended in 1814, the British had burned the Capitol, the Library of Congress, and most of the records of the first 38 years of government. Whether there was a connection between the proposed title of nobility amendment and the War of 1812 is not known. However, the momentum to ratify the proposed amendment was lost in the tumult of war. Then, 4 years later, on December 31st, 1817, the House of Representatives resolved that President Monroe inquire into the status of this amendment. In a letter dated February 6, 1818, President Monroe reported to the House that the Secretary of State Adams had written to the governors of Virginia, South Carolina, and Connecticut to tell them that the proposed amendment had been ratified by 12 states and rejected by 2, New York and Rhode Island, and asked the governors to notify him of their legislature's position. House Document Number 76. This and other letters written by the President and the Secretary of State during the month of February 1818 note only that the proposed amendment had not yet been ratified. However, these letters would later become crucial because in the absence of additional information, they would be interpreted to mean the amendment was never ratified. On February 28, 1818, Secretary of State Adams reported the rejection of the amendment by South Carolina. House Document Number 129. There are no further entries regarding the ratification of the 13th Amendment in the Journals of Congress. Whether Virginia ratified is neither confirmed nor denied. Likewise, a search through the executive papers of Governor Preston of Virginia does not reveal any correspondence from Secretary of State Adams. However, there is a journal entry in the Virginia House that the governor presented the House with an official letter and documents from Washington within a time frame that conceivably includes receipt of Adams's letter. Again, no evidence of ratification, none of denial. However, on March 10, 1819, the Virginia legislature passed Act Number 280, Virginia Archives of Richmond, miscellaneous file, page 299 for microfilm. Be it enacted by the General Assembly that there shall be published an edition of the laws of this Commonwealth in which shall be contained the following matters, that is to say, the Constitution of the United States and the amendments thereto. This act was the specific legislative instructions on what was, by law, to be included in the republication, a special edition of the Virginia Civil Code. The Virginia legislature had already agreed that all acts were to go in effect on the same day, the day that the act to republish the Civil Code was enacted. Therefore, the 13th Amendment's official date of ratification would be the date of republication of the Virginia Civil Code, March 12, 1819. The delegates knew Virginia was the last of the 13 states that were necessary for the ratification of the 13th Amendment. They also knew there were powerful forces allied against this ratification, so they took extraordinary measures to make sure that it was published in sufficient quantity. 4,000 copies were ordered, almost triple their usual order, and instructed the printer to send a copy to President James Monroe, as well as James Madison and Thomas Jefferson. The printer, Thomas Ritchie, was bonded. He was required to be extremely accurate in his research and his printing, or he would forfeit his bond. In this fashion, Virginia announced the ratification by publication and dissemination of the 13th Amendment of the Constitution. There is question as to whether Virginia ever formally notified the Secretary of State that they had ratified this 13th Amendment. Some have argued that because such notification was not received, or at least not recorded, the amendment was therefore not legally ratified. However, printing by a legislature is prima facie evidence of ratification. Further, there is no constitutional requirement that the Secretary of State or anyone else be officially notified to complete the ratification process. The Constitution only requires that 3/4 of the state ratify for an amendment to be added to the Constitution. If 3/4 of the states ratify, the amendment is passed, period. The Constitution is otherwise silent on what procedure should be used to announce, confirm, or communicate the ratification of amendments. Knowing they were the last state necessary to ratify the amendment, Virginians had every right announce their own and the nation's ratification of the amendment by publishing it on a special edition of the Constitution, and so they did. Word of Virginia's 1819 ratification spread throughout the states, and both Rhode Island and Kentucky published the new amendment in 1822. Ohio first published in 1824. Maine ordered 10,000 copies of the Constitution with the 13th Amendment to be printed for use in schools in 1825, and again in 1831 for their census edition. Indiana Revised Laws of 1831 published the 13th article on page 20. Northwestern Territories published in 1833. Ohio published in 1831 and 1833. Then came the Wisconsin Territory in 1839, Iowa Territory in 1843, Ohio again in 1848, Kansas statutes in 1855, and Nebraska Territory 6 times in a row from 1855 to 1860. So far, David Dodge has identified 11 different states or territories that printed the amendment in 20 separate publications over 41 years, and more editions, including this 13th Amendment, are sure to be discovered. Clearly, Dodge is onto something. You might be able to convince some of the people, or maybe even all of them, for a little while, that this 13th Amendment was never ratified. Maybe you can show them that the 10 legislatures which ordered it, published 18 times, were discovered so far consisted of ignorant politicians who don't know their amendments from their articles. You might even be able to convince the public that our U.S. forefathers never meant to outlaw public service who pushed people around, accepted bribes or special favors to look the other way. Maybe. But before you do, here's an awful lot of evidence to be explained. The amendment disappears. In 1829, the following note appears on page 23, volume 1 of the New York Revised Statutes. Quote, "In the edition of the laws of the U.S. before referred to, there is an amendment printed as Article 13, prohibiting citizens from accepting titles of nobility or honor, or presents, offices, etc., from foreign nations, but by a message of the President of the United States on the 4th of February, 1818, in answer to a resolution of the House of Representatives, it appears that this amendment had been ratified only by 12 states, and therefore had not been adopted. See Volume 4 of the printed papers of the first session of the 15th Congress, number 76. In 1854, a similar note appeared in the Oregon Statutes. Both notes refer to the laws of the United States, first volume, page 73 or 74. It is not yet clear whether the 13th Amendment was published in the Laws of the United States, first volume, prematurely by accident, in anticipation of Virginia's ratification, or as part of a plot to discredit the amendment by making it appear that only 12 states had ratified. Whether the Laws of the United States, Volume 1, carrying the 13th Amendment, was recalled or made up is unknown. In fact, it is not even clear that the specified volume was actually printed. The Law Library of the Library of Congress has no record of its existence. However, because the noted authors reported no further references to the 13th Amendment after the presidential letter of February 1818, they apparently assumed the ratification process had ended in failure at that time. If so, they neglected to seek information on the amendment after 1818 or at the state level, and therefore missed the evidence of Virginia's ratification. This opinion, assuming that the presidential letter of February 1818 was the last word on the amendment, has persisted to this day. In 1849, Virginia decided to revise the 1819 Civil Code of Virginia, which had contained the 13th Amendment for 30 years. It was at that time that one of the code's revisers, a lawyer named Patton, wrote to the Secretary of the Navy, William B. Preston, asking if this amendment had been ratified or appeared by mistake. Preston wrote to J.M. Clayton, the Secretary of State, who replied that this amendment was not ratified by a sufficient number of states. This conclusion was based upon the information that Secretary of State John Quincy Adams had provided the House of Representatives in 1818, before Virginia's ratification in 1819. Even today, the Congressional Research Service tells anyone asking about this 13th Amendment the same story, that only 12 states, not the requisite 13, had ratified. However, despite Clayton's opinion, the amendment continued to be published in various states and territories for at least another 11 years. The last known publication was in the Nebraska Territory in 1860. Once again, the 13th Amendment was caught in the riptides of American politics. South Carolina seceded from the Union in December of 1860, signaling the onset of the Civil War. In March 1861, President Abraham Lincoln was inaugurated. Later in 1861, another proposed amendment, also numbered 13, was signed by President Lincoln. This was the only proposed amendment that was ever signed by a president. That resolve to amend read, Article 13. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state." End quote. In other words, President Lincoln had signed a resolve that would have permitted slavery and upheld states' rights. Only one state, Illinois, ratified this proposed amendment before the Civil War broke out in 1861. In the tumult of 1865, the original 13th Amendment was finally removed from the U.S. Constitution. On January 31st, another 13th Amendment, which prohibited slavery in Section 1 and ended states' rights in Section 2, was proposed. On April 9th, the Civil War ended with General Lee's surrender. On April 14th, President Lincoln, who in 1861 had signed the proposed amendment that would have allowed slavery and states' rights, was assassinated. On December 6th, the new 13th Amendment, loudly prohibiting slavery and quietly surrendering states' right to the federal government, was ratified, replacing and effectively erasing the original 13th Amendment that had prohibited titles of nobilities and honors. Significance of removal. To create the present oligarchy ruled by lawyers, which the U.S. now endures, the lawyers first had to remove the 13th Titles of Nobility Amendment that might otherwise have kept them in check. In fact, it was not until after the Civil War and after the disappearance of this 13th Amendment that American bar associations began to appear and exercise political power. Since the unlawful deletion of the 13th Amendment, the newly developing bar associations began working diligently to create a system wherein lawyers took on a title of privilege and nobility as esquires and received the honor of offices and positions like district attorney or judge that only they could hold. By virtue of these titles, honors, and special privileges, lawyers have assumed political and economic advantages over the majority of U.S. citizens. Through these privileges, they have nearly established a two-tiered citizenship in this nation, where a majority may vote, but only a minority, lawyers, may run for political office. This two-tiered citizenship is clearly contrary to Americans' political interests, the nation's economic welfare, and the Constitution's egalitarian spirit. The significance of this missing 13th Amendment and its deletion from the Constitution is this. Since the amendment was never lawfully nullified, it is still in full force and effect, and it is the law of the land. If public support could be awakened, this missing amendment might provide a legal basis to challenge many existing laws and court decisions previously made by lawyers who were unconstitutionally elected or appointed to their positions of power. It might even mean the removal of lawyers from the current U.S. government system. At the very least, this missing 13th Amendment demonstrates that 2 centuries ago, lawyers were recognized as enemies of the people and nation. Some things never change. Those who cannot recall history heed warnings of founding fathers in his farewell address. George Washington warned of change by usurpation, for through this, in one instant, may be the instrument of good. It is the customary weapon by which free governments are destroyed. In 1788, Thomas Jefferson proposed that we have a Declaration of Rights similar to Virginia's. 3 of his suggestions were freedom of commerce against monopolies, trial by jury in all cases, and no suspensions of the habeas corpus. No doubt Washington's warning and Jefferson's ideas were dismissed as redundant by those who knew the law. Who would have dreamed the U.S. legal system would become a monopoly against freedom, when that was one of the primary causes for the rebellion against King George III? Yet the denial of trial by jury is now commonplace in the U.S. courts, and habeas corpus for crimes against the state is suspended. By crimes against the state, I refer to political crimes, where there is no injured party, and the corpus delicti, or evidence, is equally imaginary. The authority to create monopolies was judge-made law by Supreme Court Justice John Marshall and others during the early 1800s. Judges and lawyers granted to themselves the power to declare the acts of the people unconstitutional, waited until their decision was grandfathered, and then granted themselves a monopoly by creating the bar associations. Although Article 6 of the U.S. Constitution mandates that the executive orders and treaties are binding upon the states, and the judges in every state shall be bound thereby, anything in the Constitution or any laws of the state contrary notwithstanding, the Supreme Court has held the Bill of Rights is not binding upon the states, and thereby resurrected many of the complaints enumerated in the Declaration of Independence, exactly as Thomas Jefferson foresaw in Notes on the State of Virginia, Query 17, page 161, 1784. Our rulers will become corrupt, our people careless. The time for fixing every essential right on the legal basis is now, while our rulers are honest and ourselves united. From the conclusion of this war, we shall be going downhill. It will not then be necessary to resort every moment to the people for support. They will be forgotten, therefore, and their rights disregarded. They will forget themselves, but in the sole faculty of making money, and will never think of uniting to effect a due respect for their rights. The shackles, therefore, which shall not be knocked off at the conclusion of this war, will remain on us long, will be made heavier and heavier, till our rights shall revive or expire in a convulsion. We await the inevitable convulsion. Only 2 questions remain. Will we fight to revive our rights, or will we meekly submit as our last remaining rights expire, surrender to the courts, and perhaps to a new world order? I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will faithfully discharge the duties of the office on which I am about to enter. So help me God. Where we go one, we go all. Please subscribe to our backup channels on YouTube: Inglorious Patriots, Net4Truth USA 2 Patriot Channel, and Ethernet Warriors. You can also catch us on BitChute.com/Net4Truth USA, remonetized.org, net/user/Inglorious-Patriots9 and drop.space / @net4truth USA. All the links are in the description. We fly so close to the target, we are on our 5th fighter jet. We will be relentless and persistent until the enemies of freedom are defeated. You can support this channel by using the links in the description, but for a $100 donation, I will personally send you a autographed hardcover special edition copy of Land of Childhood's Fears. Also, visit my bookstore at lulu.com / net4truth USA. If you are viewing this video on BitChute, you can use the links in the description to support us, or simply click the green $ dot on our video to support this channel. Thank you. Links are in the description section.